Hey
Hey
guys.
guys,
Hello, my lovely
how are
ladies.
you? Can you guys hear
Julie.
me? I just threw in my AirPods, so I want to make sure.
Yeah, we can
Yeah,
hear you.
okay, good.
Julie, you have like a blue. Does everybody see Julie the way I do?
Am I
What?
blue?
She's all like the
No,
whole screen is blue. I don't know what's going on.
no, she looks
No,
good to me.
we've got a poltergeist. I don't know what's happening. Okay. No
No
worries.
blue, no blue man group over here.
Do you have your
Anyway.
cursor on me? Because when I do that, it turns
Maybe
you
I
guys a weird
do.
color.
Oh, I did. Thank you for
Mhm.
that.
Oh,
I'm
weird.
always learning something over here.
Oh, I never knew. Yeah, I never knew that.
Me neither.
Anyway, happy Thursday. It's summertime over here. Yeah, there's no school, so like our show is really the only thing that helps me keep track of the days of the week. Every day is just a day.
It all blends together. I
Yeah.
know the feeling. And this week has been weird. Like time sped up and slowed down a couple times for me.
Yeah.
Yeah, it's been a week.
Yeah. So you may have noticed that we changed our show at the last minute. The witnesses' response to, or their, I guess, support of their motion to dismiss was filed late last night. And a lot of times we'll do an emergency show, the day it's filed. But thankfully we had this show already scheduled. So we figured, and we like to cover those right away. So that's what we're going to do. And we will announce a later date for our jury show.
Jury, which is going to be good.
Yes.
And it's also just a warning because we're known for this. Probably going to be a two-parter. So
Oh,
the jury show? Oh, the jury show.
The jury show.
Yeah,
Mhm.
yeah, for sure.
Yeah.
So
I'm excited. So I haven't read this yet.
really? Oh, it's a barn burner. It's
So-
really good.
Let me tell you something. Last night, Pacer was acting very, very odd. So I was trying to get it. By the time I could actually get into Pacer and get it, it was past my bedtime. So I fell asleep reading it, like glasses on. Yeah.
So did your account do that migration thing? Because I started to do the migration where they sync those two up and then I was like, I am tired. I'm not doing this anymore.
No, it just wouldn't let me in. It just kept spinning.
Yeah, I think it was an issue with Pacer because I couldn't get in either. Julie was like texting me, can you get in? And I'm like, I couldn't get in either.
I couldn't get in and I gave up. I was tired.
I think what made me so mad about it is all day long I was on Pacer refreshing and waiting. And then finally, I get home from work at night and I'm like, all right, I'm just tired. And then Jenny texted or Carrie texted me and said, it's up. And then I couldn't get in. So then I was double mad, super mad.
Yeah, it's so annoying. All these, I was talking to somebody on Twitter about this today, about how there are some states that are great, right? Florida, you log in, you get all the documents, every single docket entry, the document is posted. And then in Indiana is another great state. It was great in Delphi.
Indiana is very easy to use and all of our civil stuff is online, but our criminal stuff, normally, you can't even get it by email. You have to, you could pay for it online.
Right.
But you have to actually go to the courthouse and pick up those
to get the documents. Yeah.
It's like that in Massachusetts too, right? You have to go to get those things.
Some of them are on, some of them you can download in Massachusetts, but it's completely crazy how we don't have a standard system where just regular human beings can access public information. It's a problem.
I mean, I do like Pacer. Pacer is pretty cool.
Pacer's nice. Well, before this weird migration.
Yeah.
Pacer is nice, except that I didn't know that, because I've done the same thing, Julie. I've been in the case and I've been hitting refresh, waiting for docs to hit. I didn't realize they charge you 25 cents every refresh.
Yes.
My last Pacer bill, I was like, I'm sorry, it's what?
Yeah, exactly. I know. Yeah, I got a summary at the end once the docs finally did hit and everything. And I think it was at the end. I can't remember, but at some point I got to stop. And I was like, oh, well, I won't be doing that again.
No, it's brutal.
My husband has not asked me who Pacer is yet, so it's not that bad.
Oh no.
And we don't want that to happen. But yeah, I was really shocked when I saw it. I was like, what?
Yeah.
Yeah. No, it's really expensive.
Yeah. Yeah.
So, yeah, that's rough on federal
A
cases.
moron like me, and you just keep re-downloading the same thing because you can't find it wherever you put
Yes.
it. Like,
that happened to me too. When they initially moved everything over there and I was trying to download all the docs, I downloaded them, couldn't find it, had to re-download.
Yeah.
Again.
And you're thinking, oh, it's just like 10 cents a page.
Right.
Yeah.
I know,
Well,
it sounds like
Yeah.
that's how they get you.
yeah. Yeah.
Marketing.
Scam. Our federal government is running a scam.
Right. Yeah, this one's long. So the one we're going to go over tonight is 23 pages. So that's.
So can I just
That's a
say
cheaper
before we start this, I was really surprised with Karen's, what do you call that? The amended complaint with what she did. It was over 1,500 pages that she is expecting the judge to read. And what's more, like, you know, there's some complicated cases and you might need that much documentation. I get it.
Right. Like a
What Karen
case
claimed those documents that she attached said and what they actually said are two very different things. And I would think that might irritate a judge a little bit. That's just my opinion. I'm not an attorney. I don't deal with federal judges, but I have to tell you, if I was that judge and I read all that stuff, I would be like, ma'am, what?
Mm-hmm.
You just made me
Did
read all
you
that.
get through it all?
Yeah.
You read it all?
Oh, I read, I wanted to reread the medical examiners just to make sure that it wasn't something that I missed what she was claiming. And yeah, that's not what was said. So in this, I don't know if you guys noticed, one of the attachments has John's full report from Ian Whiffen, his phone. So if you didn't download that and you want to read it, I have it. I can email it to you.
That'd be great.
Yeah.
I'd love to see it. No, I just got exhausted when I saw the page count. And
it was so sad. So it was attached to the witnesses. It's so sad to read Ian Whiffen's report. It's really, I read it at lunch today and I was like, wow,
It's
I'm
very
already
sad.
having a rough day. And now it's even worse. Wow, it's really sad.
I mean, it's his last movement. It's documented, like his very last. Yeah, it's sad.
You can see all of it. And so it's basically you're reading it and you're watching.
Yeah.
You're
slow
watching
motion.
It's a lot.
Really
It's a lot to get through.
All right. Well, should we switch to comedy and look at the document?
Yeah, it's a great response. I love it.
It is. It's really well.
And you know, if you guys have kids that are teenagers,
Is that
have
bigger?
them practice their writing skills, because being able to write this way, that's a huge contributor to success.
Yeah, it's good.
Yeah, I think that's better.
Okay. Can you see it?
Yes.
Do you want me to read or?
I do not want to read.
Okay. I can read. Okay. Preliminary statement. Karen Reed's opposition does not rescue her amended complaint. Instead, it confirms the amended complaint's fatal deficiency. Each claim she asserts against the Commonwealth's witnesses is at its core an attempt to punish citizens for cooperating with law enforcement and testifying under oath, a theory of liability that no court has ever endorsed, and that the Massachusetts anti-SLAPP statute was enacted to foreclose and the Supreme Court precedent squarely prohibits. No court has ever endorsed. That's wild.
Yeah.
In her opposition, Ms. Reed concedes that the Supreme Court case law bars the claim based on sworn testimony or statements to police, yet in the next breath disregards that controlling law and argues without legal citation that her allegations that the Commonwealth witnesses allegedly lied to the police, provided false testimony, are sufficient to state a claim. The opposition fails to cite a single case where an acquitted criminal defendant successfully sued lay witnesses for malicious prosecution based on testimonial activity. That is because no such case exists.
Wow.
That's wild to me.
Yikes.
Yeah.
Ms. Reed attempts to escape the straightforward boundaries of the Massachusetts anti-SLAPP statute, absolute immunity doctrine, and state and federal law by recasting the Commonwealth witnesses' conduct as something other than protected activity, principally by her alleging a conspiracy to manufacture or destroy certain evidence purportedly related to the death of Officer O'Keefe. Ms. Reed's allegations do not support such characterization, and she fails to cite any legal authority to buttress her arguments. Any comments there?
Yeah.
With respect to her anti-SLAPP defense, Ms. Reed fails to identify any non-petitioning activity that is germane to the claims pleaded against each Commonwealth witness. In addressing the second anti-SLAPP prong, the opposition itself and evidence submitted with it defeats her arguments. Most telling is Ms. Reed's affidavit, wherein she testifies under oath for the first time since Officer O'Keefe was killed. In that sworn statement, it is what Ms. Reed fails to say that speaks the loudest. Ms. Reed does not address the single most critical fact underlying her entire complaint against the Commonwealth witnesses, that she ever witnessed Officer O'Keefe enter 34 Fairview.
Amen. That's
Which is interesting because she said it not under oath, right? She's made that claim in interviews that she saw him. A ridiculous story about seeing just his head cross the threshold, which I don't know how that works, but okay.
So how do you get around that?
Yeah. Yep.
I don't know.
I love how they pointed out this is her very first statement under oath.
Yep.
Love that. And they say it more than once in here.
Yeah. And so she's going to have to really practice for all these depositions, right? Because she's got to give the same story in all of them.
Yep. But the problem is she can do that, but she's already screwed herself because of all the interviews and things like that. So, I mean.
Right. So, but it also kind of indicates that she is aware that she needs to tell the truth here, right? Like she needs to not say something that has contradicted her other statements. You know what I mean?
Yes.
Mm-hmm.
Yeah.
Well, remember when we all read her affidavit, we were like, this is the most generic, non-information, like there's zero information in this thing other than her name and her age. Yeah. Like there was,
for someone who likes to talk a lot to the media, she sure didn't want to commit to anything in that affidavit.
Right. Nothing. And remember, they filed it and they did not file her affidavit with it. They waited a day to file that affidavit.
They did. Yeah, they filed her affidavit the next day.
Interesting.
Yeah, because I had tweeted out about it. I think it was right before noon that next day. And then like an hour later, her affidavit appeared.
Right.
I'm not saying there's any correlation there to those two things.
It's a conspiracy.
Right. However, it was filed separately.
Right.
Okay. So that omission is not an oversight. It's an admission. Equally telling is the second glaring admission in Ms. Reed's affidavit. She does not dispute that she made several incriminating statements on the morning of January 29, 2022. Thus, she does not refute the accuracy of Ms. McCabe's statements to police or Ms. McCabe's related testimony on that issue.
Yep.
The opposition compounds these failures by misrepresenting both the record and the law. With respect to the record, it grossly mischaracterizes exhibits in an attempt to prove that the Commonwealth witnesses lied to investigators and fabricated evidence. On the governing legal standards, the opposition fares no better. First, it misreads the Supreme Court precedent to suggest that this court is forbidden from hearing anti-SLAPP motions. Moreover, it misinterprets Supreme Judicial Court authority in an attempt to place the Commonwealth witnesses' statements to first responders outside the scope of the absolute immunity privilege. The opposition similarly misconstrues inter alia the accrual rules for certain torts, the elements of civil conspiracy under Massachusetts law, and the intrinsically coercive standard of the MCRA in each instance stretching the settled doctrine past its breaking point. What Ms. Reed is seeking is clear. She wants a federal court to punish witnesses toward whom she harbors clear animus for testifying and providing information to police simply because she contends that the testimony and information may have contributed to her arrest, indictment, and prosecution. Every court has rejected such prior attempts, and this court should do the same. So they keep repeating that there is no precedent for what she's asking for.
Mm-hmm.
Yeah, it's very in the spirit of Karen Reed too.
Yeah, create new law for me. Create new law. Remember,
Right.
she's done that before.
Yeah, she wanted to get rid of Lampron, remember?
Right.
And she's like, and her reasoning was, well, I don't know what I don't know. So you should be allowed to go violate people's privacy because you don't know what you don't know. I mean,
we don't know what we don't know about her phone. So, I mean,
right. I mean, she factory reset her phone. So,
yeah.
Right. Okay, so here's the argument. The opposition fails to rebut the anti-SLAPP special motion to dismiss. Burke versus Choi does not overrule binding anti-SLAPP precedent. Ms. Reed's principal argument against the Commonwealth witnesses' anti-SLAPP motion is that the Supreme Court's recent decision in Burke versus Choi renders the Massachusetts anti-SLAPP statute inapplicable in federal court. This interpretation is misguided and attempts to establish controlling precedent where none exists. In Burke, the Supreme Court addressed a narrow question, whether Delaware's affidavit of merit requirement for medical malpractice actions could be enforced against a plaintiff proceeding in federal court when under diversity jurisdiction. The court held it could not, reasoning that blah, blah, displaces a state law demanding more. The court emphasized that Rule 8 sets a ceiling on the information that plaintiffs can be required to provide about the merits of their claims, and that Rule 12b-6 provides the sole merits-based grounds for dismissal, prohibiting courts from looking to matters outside of pleadings. Burke's entire analytical framework thus turned on the identification of a direct conflict between a state-imposed pleading or evidentiary gatekeeping in the federal pleading rules. That conflict is wholly absent here. The anti-SLAPP statute does not add to the plaintiff's pleading burden. Instead, it creates a unique mechanism by which a defendant may file a special motion to dismiss claims arising from petitioning activity. And then there's a cite. Indeed, the Burke court's own logic confirms the this is a big word, inapplicability of its holding to the anti-SLAPP context. The court found displacement because Delaware laws and Rule 8 answered the same question, namely whether a complaint may be dismissed for failure to furnish evidence at the outset of a case. An anti-SLAPP motion, by contrast, answers a fundamentally different question, whether a facially sufficient complaint targets petitioning activity, and if so, whether the non-moving party can demonstrate that the petitioning activity lacked a reasonable basis. The inquiry doesn't supplement pleading obligations. It provides an additional defense side procedural protection akin to qualified immunity screening. So then the footnote is that the Burke court expressly distinguished laws that create substantive rights or liabilities from those that merely regulate pleading mechanics. The court acknowledged that a state law may have some practical effect on, and then you have to go down here, the party's rights, yet remain enforceable in federal court so long as it does not answer the same procedural question as a federal rule. Massachusetts anti-SLAPP statute does far more than regulate pleading. It creates a substantive immunity from suit for petitioning conduct, attaching substantive consequences such as cost shifting to its invocation. Applying Burke's own framework, anti-SLAPP laws do not address what information a plaintiff must provide about the merits at the outset of litigation. So then they say the First Circuit previously employed the same reasoning as Burke in the anti-SLAPP context, holding that anti-SLAPP special motions can be brought in federal court. See Godin, which is one of the ones that she had cited In Godin, the circuit held that Congress, in approving Rules 12 and 56, did not intend to preclude special rules designed to make it more difficult to bring certain types of action where state law defines the cause of action, and therefore anti-SLAPP statutes can be applied in federal court. The court is thus bound by the controlling precedent that actually addressed the questions of whether anti-SLAPP suits can be maintained in federal court. And then here's a good one. At the very least, Ms. Reed's conclusory assertion that Burke has unmistakably cast Godin into disrepute is misplaced. Ms. Reed offers no explanation as to how Godin is overruled by Burke. Indeed, for a district court to disregard binding circuit authority, the Supreme Court must have explicitly revoked or unmistakably determined that authority. That is not the case here. Burke did not even address, let alone expressly revoke, the principle recognized in the First Circuit that anti-SLAPP special motions can be heard in federal court, nor did it undermine the reasoning that the First Circuit applied in Godin. So they're saying her citation has no merit.
No support. Yeah.
Against her own citation.
Mm-hmm.
Yeah, I mean, that was what had confused me with her amended complaint, was that whole argument. The first one she filed, what she filed in response, and then the amended complaint, I could not follow what they were trying to say. I was like, this doesn't make sense. And I just assumed that it was because I didn't have the same kind of knowledge that they have. But this kind of confirms that what they were saying was ridiculous.
Yeah. They're just throwing it at the wall, like throwing spaghetti at the wall and hoping something sticks, like we always say.
Yep.
Faced with the reality that her claims are grounded exclusively in petitioning activity, which this is going to be a theme kind of throughout this whole document, the opposition points to a handful of ancillary allegations to manufacture the relevance of non-petitioning conduct. So she's going to bring in a bunch of stuff that she says is bad, but it doesn't relate to petitioning activity, which is why they're saying it should be rejected. They're like, even if you assume that all of this stuff happened, it doesn't matter because it isn't related to the petitioning activity.
Right.
Tellingly, the opposition does not discuss or even cite, and then citation, discuss through the opening motion. This case made clear that in assessing whether the only conduct complained of is petitioning activity, a judge considers only the allegations that are relevant to the discrete causes of action brought. Where the purported non-petitioning activity, so basically the conspiratorial content is what they're referring to here, does not bear any apparent relation to the courses of action, it does not defeat the first prong of the anti-SLAPP analysis. Ms. Reed ignores this doctrine because it destroys her argument entirely. So she's saying, here are all the elements of how these people conspired against me. And what they're saying is these two things don't touch, right? The petitioning, the protective petitioning activity, and the claimed conspiratorial conduct, those two things exist separately and don't affect each other.
It's so on point, right? Just to ignore what we don't want to talk about or what,
Right.
may not prove her point. I mean, that's what they all do.
Yeah, I mean, it's kind of what you have to do, right? If you want to get something dismissed.
Mm-hmm.
While the opposition goes to extreme lengths to bolster certain allegations in the amended complaint, on its face, the purported non-petitioning activity boils down to only those, albeit preposterous, allegations that the Commonwealth witnesses moved Officer O'Keefe's body, destroyed or discarded 2 cell phones, and communicated about the investigation with one another. As detailed in the opening motion, these allegations are irrelevant to the principal question underlying Ms. Reed's primary tort claim, whether each of the individual Commonwealth witnesses commenced or continued the prosecution of Ms. Reed. So they'll use this language throughout. So let's say there was a Faraday bag, right? The Faraday bag did not commence prosecution against Karen Reed. If it existed, if all of these, fantastical things existed, they still didn't bring to life the prosecution against Karen Reed. Sorry, my allergies are killing me. The opposition also fails to address any alleged non-petitioning activity with respect to each claim asserted against each Commonwealth witness. So I'll read the footnote here before I read the next sentence. For the reasons addressed in the opening motion, as well as those described in from Ms. Reed's continued reliance on the allegation that Ms. McCabe Googled House long to die in cold at 2:27 a.m. should not be afforded any credence. The singular expert whom Ms. Reed proffered to render that conclusion was subsequently determined to be utterly unreliable between her first and second murder trials, as evidenced by Ms. Reed's decision not to call him as an expert during her second trial. Moreover, the opposition cites directly to the testimony of another expert, Mr. Ian Whiffen, who credibly testified that Ms. Reed's alleged Google search conspiracy was a farce. Ms. Reed should not be permitted to continuously rely on evidence, especially in an attempt to satisfy a difficult burden that she knows to be false and misleading.
Yeah, and that's what I found about her entire amended complaint. What she was saying and the things that she was providing did not say how she was interpreting them. I don't know how a judge is going to react to that.
Yeah. No, she flat out lied about what people said in their statements.
I just don't get it. I don't understand.
The opposition also fails to address any alleged non-petitioning activity with respect to each claim asserted against each Commonwealth witness. While the opposition desperately tries to break out the allegations against each Commonwealth witness in each cause of action, it only confirms that Ms. Reed impermissibly groups these 5 Commonwealth witnesses collectively to mask the absence of any germane non-petitioning activity specific to them. So that kind of goes to the whole Nicole Albert thing, right? Yep. They're like, she didn't even talk to the police until, after this whole thing had started.
Yep. Higgins as well. Both of them were on the 3rd.
Yeah. So her grouping them is saying they're acting as a unit, right? So all of these things are the violators. Indeed, in attempting to circumvent the opening motion's group pleading argument, the opposition fails to cite a single case supporting the proposition that moving a body, discarding a cell phone, or communicating with friends and family regarding the death of a loved one could constitute initiating a criminal prosecution for malicious prosecution claim. So imagine like you're calling 911 and somebody says that initiates a prosecution. Like those are two really different things.
It's such a huge stretch
to
try and connect. And I don't know, it's a slippery slope to go down that.
Yeah. I mean, it's a chill. It's by nature chilling, a chilling effect.
Yeah.
The only allegations that could relate to that claim and Ms. Reed's other claim would be the Commonwealth witnesses' statements to police and their trial or grand jury testimony, all of which are paramount petitioning activities. Because it's not like you sign up to go to the grand jury. That's not
you don't.
What happens.
No volunteer.
Because Ms. Reed's claims against each of the Commonwealth witnesses are based solely on petitioning activity, she must show by a preponderance of the evidence that the petitioning activity had no legal or factual basis, a difficult task. So then they have a citation. Ms. Reed offers zero evidence showing that each Commonwealth witness's statements lacked any factual basis. She doesn't even attempt to dispute the Commonwealth witnesses' statements that Officer O'Keefe never entered 34 Fairview, or Ms. McCabe's statements regarding several incriminating statements made by Ms. Reed on January 29, 2022. Yep. Ms. Reed's entire case hinges on whether or not these statements were lies.
Yep.
Yet remarkably, in her first sworn testimony since Officer O'Keefe was killed, Ms. Reed conspicuously omits any assertion that she ever witnessed Officer O'Keefe enter the home. While that omission destroys any contention that the Commonwealth witnesses' statements were devoid of any factual or legal basis, Ms. Reed's omission undoubtedly reflects the truth. She never saw Officer O'Keefe in her 34 Fairview because, in fact, he did not. That is what she told the police on January 29th, 2022. That is consistent with the data admitted during Ms. Reed's second murder trial. That is consistent with the crime scene. That is also consistent with the testimony of every single witness. And even though they're not, the concern here would not be like litigating these facts, right? Their concern is just whether or not this is protected petitioning activity. That is a pretty damning set of facts.
Yeah.
Ms. Reed's affidavit also conspicuously omits any denial that she made incriminating statements the morning of January 29, 2022. In the amended complaint, Ms. Reed complained that Ms. McCabe allegedly gave false testimony that Ms. Reed made incriminating statements on January 29, 2022. Ms. Reed's failure to dispute this in her first ever sworn testimony not only confirms her responsibility for the death of Officer O'Keefe, but also that Ms. McCabe's statements and testimony regarding the incriminating statements constitute protected petitioning activity grounded in a clear factual basis. So
she's not, she did not do herself any favors whatsoever. She just made it worse for herself once again.
Right. Hang on, I lost my place. Rather than attempt to show that the Commonwealth witnesses' statements were devoid of factual or legal basis, Ms. Reed instead cites evidence attempting to establish that she did not murder Officer O'Keefe and attack the Commonwealth witnesses' credibility. This effort to deflect not only fails to address the relevant anti-SLAPP issue, wherein credibility determinations are decided against Ms. Reed, but also fails to achieve its stated goal. Instead, Ms. Reed mischaracterizes the relied upon evidence in an egregiously self-serving manner, deliberately misleading this court regarding what was admitted at trial.
Lydia, I have to say something. I just pulled up my copy and I was sitting here as you were reading, like, oh my God, we underlined all the same things. I forgot I sent this to you.
No, it's your copy.
Like, oh my gosh, we were like so like this.
Right. Simpatico, right? Yep. Okay, so then there are a couple footnotes. See the supplemental declaration of James L. Tuxbury from the expert report concluding there was no evidence of a flight climb event occurring once the device had arrived at Fairview Road, that the battery temperature of Officer O'Keefe's iPhone declined for several hours after 12:37 a.m., and that the final user interaction with the device was at midnight 32:09 when the device was locked, and the last step of the health data was recorded at midnight 32:16. And then there's another footnote that says, in doing so, Ms. Reed gratuitously ignores the critical evidence reflecting her responsibility for the death of Officer O'Keefe, his and her phone data, his phone temperature, his phone pocket state. Feels like reading truth, right? Mm-hmm. His phone GPS information, her car data, the fact he stopped moving at the very moment she completed a high-speed reverse, the significant damage to her right rear taillight, which cannot be explained away by her contact with Officer O'Keefe's Chevy Traverse, the evidence at the crime scene, and her own several incriminating statements on January 29th, 2022. I can hear Truth's voice saying that, all of those things.
Don't start a conspiracy. They're going to think Truth is
James Tuxbury.
Yeah.
Yes, could be.
This part blew me away, what you're about to read. Like, I literally cannot believe she had the
this is kind of crazy.
Yeah. I mean, that's why I reread that testimony, the attachment that she put in, because it was like, I could have missed something. And again, if I was the judge, I would be like, I'm sorry, ma'am, what?
Yeah.
You made me read all of that, and it does not say what you're saying it says.
Yeah. I've never been a
wild.
judge, but I would assume they don't like being lied to.
Right.
Well,
And I mean, that's
is she expecting the judge not to verify? I mean,
Oh, like, here's my project and look at all this stuff with it, so I must be telling the truth. I don't know.
Right.
yeah, I mean, I could see that. I could see where she would
Yeah.
just try to make it so overwhelming that maybe
Right.
he wouldn't look into anything, you know?
Mhm.
I don't know.
For example, the opposition cites the trial testimony of Dr. Irina Scortibello. Ms. Reed asserts, without, I don't know how to pronounce that Dr. Scortibello testified that Mr. O'Keefe's injuries were not consistent with the vehicle strike, but rather a physical altercation. However, a review of the trial testimony reveals that Dr. Scortibello never said anything of the sort. To the contrary, when asked whether the injuries sustained by Officer O'Keefe could be consistent with being struck by a vehicle and then going to the ground, Dr. Scortibello testified, yes, they can be. Scortibello also testified that she didn't see any major signs of what she would call a significant altercation. Ms. Reed also states, again without proper citation, that Scortibello's testimony supports the allegation that Mr. O'Keefe suffered dog bite wounds. Again, this is false. Instead, when asked about the scratches found on Officer O'Keefe's right arm, Scortibello asserted she didn't know what caused them. At no point throughout her testimony did Scortibello state anything about a dog or dog bites.
What?
And so,
Why would she say this?
and what he's saying there is she made all these assertions and said the testimony said this, and she didn't cite anywhere. Like, she gave she gave the judge all this information for her to read, did not tell her where it was cited in that testimony, which again, I would think that would make a judge a little bit angry. I mean, I read the whole thing and it made me a little bit angry when I got done, and I was like, none of that was in there.
Yeah. Like, just be straightforward with me. That's how I would feel as a judge. Be straightforward. If you're going to play a game and dance around the truth and try and mislead me, like, my patience is going to go from 0 to, or 100 to a 0, right?
Yeah, well, and you put a citation in because there isn't any place to citate because she made it up.
Right. That's a good point.
You're not doing yourself any favors doing this, because like we're all saying, the judge is not going to be happy once he realizes what's going on here. Like, how does she think that she's helping herself?
I don't know.
Because now everything you say, the judge is second guessing or wondering, like, are you telling me the truth? Is this something that, actually happened?
Right. And is there an exhibit that supports what you're saying?
Yeah. I mean, I would question everything she said from here on out.
Right.
Is this still a game of optics for them? Like, is this still, like, as we know, in the criminal case, the defense was using these motions for optics, right? They wanted the public. Right. But then again, they were pushing for the jury pool to already come in with a bias at that point. I mean, what is the point of this? Are they trying to do the same exact thing?
I don't know. I don't know what the plan here is with all this stuff that they're throwing out. Because at some point you can make all of these allegations, you can make all of these assertions. You're going to have to prove it. This is not criminal court anymore. It's civil court. And she doesn't have those same protections, right? So when you're a criminal defendant, because your freedom is on the line, you can kind of push the envelope. She doesn't have that anymore. That's all gone. She has to prove everything that she's saying. And I just don't see how she's ever going to do that. Yeah. And then when she does things like this, she literally makes it up. I don't get it.
Yeah, no, it's bad. In addition, and it gets worse. In addition to the testimony of Scortibello, Ms. Reed relies on testimony of Ian Whiffen. Specifically, the opposition states that evidence was presented through Whiffen that Mr. O'Keefe's phone was at some point in the Alberts home. Ms. Reed fails to point to the court where Mr. Whiffen's testimony, he made such a statement, because he never did. And there's emphasis on that. Indeed, the testimony annexed to the opposition concerns only Ms. McCabe's Google search and Mr. Whiffen's conclusion that such search did not occur at 2:27 a.m. And then here is a great footnote that I
This
have
was
something to say about.
insane.
Insane.
I tweeted about this because again, blew my mind.
Indeed, the opposition is littered with citations to hundreds of pages of trial testimony that fail to direct the court to the precise portion in the trial testimony that purportedly support Ms. Reed's assertion. The filing also fails to include the copy of Attachment 4, selectively curated grand jury testimony, which was not subject to a motion to seal or provided to defense counsel prior to the filing of this reply, despite counsel's best efforts to obtain it. Moreover, the opposition and supporting exhibits were filed without optical character recognition, OCR, which would require taking the affirmative step of printing the documents, scanning them, and then re-uploading them prior to filing. Of course, filing documents without OCR deprives the court and counsel of the ability to effectively search those documents. These efforts only underscore the opposition's wholesale attempt to mislead this court regarding critical facts by frustrating the ability to verify the accuracy of Ms. Reed's representations. And Acrobat, which is, I assume they're using, has OCR turned on by default. So if you open a document in Acrobat, it's going to have OCR on it. So they either affirmatively took the step of scanning, like they said, or they turned OCR off and saved the document deliberately, which takes a lot of work, actually.
Yep.
Why would they do that? Why would they do such a thing?
Yeah, you really have to wonder, because in 2026, are we really out here scanning documents that we created on a computer? Are we doing that?
Might as well.
There's only one.
Over.
Yeah, I mean, I said this in my tweet. There's only one reason to play these games, and we all know why that is. There's only one reason not to attach something that you cite. There's only one reason not to tell the court or the other attorneys where they can find the testimony that they're trying to claim freeze Karen Reed. There's only one reason to take all of these steps. I mean, look at all the steps they had to take. Print the document, scan the document, re-upload the document. I mean, that is intention. Even if it was just so simple that they turned off OCR, like you said, Lydia, it's an intentional step. It's an intentional task to make it so that nobody can find what they're talking about.
Yeah, it's great.
Yeah,
exactly.
And if you were so innocent, if you were an innocent person, if you were somebody that was trying to prove your innocence, why would you do that?
Exactly. You wouldn't do that.
And it's just kind of upsetting that an attorney would agree to that. Like, that's kind of gross.
Yeah. I don't know how they're going to handle juggling all this stuff, because this is a lot of Wizard of Oz stuff that they're doing here with all these cases, where it's like at some point people are going to know who the man is behind the curtain.
For
like,
sure.
We're all going to find out. Like it can't go on forever, and it just shows it. I mean, this is ridiculous.
Yep. Why doesn't Free Karen Reed ask questions about this?
Because they're never going to. They just see dog bites. They see all the things that she has repeated, and again, like that rote memorization. She knows that works with them. If I just repeat it and repeat it and repeat it,
sure,
it suddenly becomes truth. So she knows that the people that believe what she's saying are never going to look behind the curtain.
They never used a critical eye looking into her. It's like they use a different measuring stick when they analyze the Commonwealth, and they analyze the witnesses and everybody else. And then the measuring stick they use to look at Karen is completely different, if they even measure at all. It's it's wild. It is beyond wild.
I mean, this should be offensive to them. They've given her their time, their money, their support, 100%. And this is how she repays it. I mean, by things like this. This would be offensive to me if I had given all of that to her.
I mean, imagine if tables were turned, right? And it was the other side doing that.
Yep.
Right.
Yeah. Yep. Can you? Yeah, we'd never hear the end of it.
No.
No. Yeah. We'd be on our deathbed and somebody would be tweeting on Twitter.
Before you take your last breath, can you comment on this?
Right. Oh my gosh. Okay. Moreover, Miss Reed continues to assert her innocence by contending that Miss McCabe conducted a Google search at 2:27 a.m. regarding how long it takes a person to die in the cold, relying on the testimony of, quote, expert Richard Green. As Ms. Reed is aware, this theory was nullified during her second criminal trial as evidenced by the testimony of Mr. Whiffen that Ms. Reed, mistakenly or otherwise, attached to her opposition. Indeed, based on the issues with Mr. Green's theory that surfaced between Ms. Reed's first and second criminal trials, Ms. Reed chose not to call Mr. Green at all during her second trial. So this is very damning, right?
Yeah.
Like relying on something that she didn't even, that her attorneys didn't even rely on is wild.
There's no McNasty citations in here.
No, there aren't. Isn't that crazy? Why is his report not attached as an exhibit?
And she attached Whiffen's report.
Yeah. Right. Whiffen's report that absolutely disputes what she's claiming.
Yeah, that's funny. I wonder if they forgot to like put something in there that said we're attaching this report because it's not true, or what happened? Like, how did that happen that they attached the report debunking their own?
I think they think that the judge is going to be like, oh, I have to look at everything that you're saying is fact, and I'm not going to verify. And maybe. I got to tell you, I mean, I think Denise Casper is a very smart woman, and people don't get to her position without the trust but verify mantra, right? Yeah. So if you're handing it to me, I'm going to look at it. And if it doesn't say what you say, says, I'm going to be mad. That would at least be me. I would be very angry about that.
Right.
That's right. This is Casper. I keep there's so many lawsuits.
Yeah,
I keep forgetting which judge is which.
Yes. No, it's a lot. It's a lot. For sure. Thus, her continued reliance on such stale, false, and unsupported assertions to project this conspiracy theory is at best a red herring and certainly does not establish that the Commonwealth witnesses' statements regarding the whereabouts of Officer O'Keefe are devoid of any factual or legal basis. The opposition's flagrant mischaracterizations of the testimony presented during Ms. Reed's criminal trials are entirely improper and serve only to deflect the court's attention away from the plethora of evidence pointing to Ms. Reed's liability as outlined in the detail in the opening motion. Court should not credit such gamesmanship, particularly when assessing whether Ms. Reed has satisfied her burden under the anti-SLAPP analysis. Accordingly, the Commonwealth witnesses' special motion to dismiss should be granted. To the extent that the opposition mistakenly included the wrong portion of Mr. Whiffen's testimony, the assertion that he ever testified that Officer John O'Keefe's phone was at some point inside the Alberts home is still false. During Ms. Reed's second murder trial, Mr. Whiffen discussed the GPS location data extracted from Officer O'Keefe's phone, but never testified conclusively that Officer O'Keefe's cell phone was ever inside of 34 Fairview. To the contrary, Mr. Whiffen stated that in his expert opinion, Officer O'Keefe's cell phone never moved far away from the flagpole outside of 34 Fairview between 12:24:33 a.m. and 6 a.m. on January 29th, 2022. And then they cite law and crime.
Oh, look at that. They actually give a link to prove what they're saying.
That clip. We've played it on this show, I think, more than once. I think what Karen is relying on is he gave examples for why the location data might not be high quality, right? So when that bubble kind of expands. And if I was a judge and I was reading his report and I came to that and realized that this person is trying to say this makes this factual, I would not be impressed. I would be a little angry about it.
Right.
Yep.
For sure.
Especially when you see how the 8 seconds, I think, total that the little bubbles went over the house and they didn't even hit the garage where they're claiming he went in, and
Well, and it's I mean, if you go and you look at it again, Guarino says that John would have to walk 32 miles per hour in order to make it there and back to the flagpole. It
And
just,
that's not with a fight in between, Tuesday, right? That's just
Right.
going back and forth.
Right.
That's not,
Yeah, run in and have a fight, get chewed up
Yeah.
by the dog
And
for
then
8
run out.
seconds, and then
and it's disingenuous to say that Ian Whiffen believes that John walked into that house because he was asked by looking at the data, is it possible? And in that one question, if we're looking at that one data point, which he's asked about, he says technically, yeah, right? And that's the end of that question. But when you add in all the other data points and he looks at it, that's why his opinion is that John
right,
never left
right.
the flagpole area. So it's taken out of context.
Yes.
Right. That's the thing.
Yes.
His final opinion, if you listen to that, when Hank has him summarize basically everything, his final opinion is that no, John did not, his phone did not leave the vicinity of that flagpole.
Yeah.
Right.
So,
And that's
yeah.
what they rely on. The people who think Karen is innocent and really push it is they rely on little pieces isolated. They don't look
Not
at the
the full picture.
totality of evidence. Yeah.
Yeah. Right. I just know, I love this. To the extent the opposition mistakenly included the wrong portion
Right.
of Whiffen's testimony, that reading that, Karen
Oof.
definitely called someone a pervert at
Yes.
some point.
She was
I don't know who got it from her, but somebody got it from her.
Right.
Yeah.
Okay.
I don't know. It just reminds me of like all the things that she's doing with all of this stuff. It reminds me of like one of those great fraud shows. Like, how long can she keep this up?
Yeah.
How long is she going to be able to keep this up? Because at some point, the walls are going to tumble down.
No.
Yeah.
I mean, she has to be so stressed. I mean, she has so many balls in the air right now.
Yeah, it's a lot.
Yeah, and
Yeah.
all the balls are hinging on lies.
Yes.
I mean, I would be a complete mess. I would be. I don't even know how I would handle that. I couldn't handle it.
Well, you
Yeah.
wouldn't be in this situation because
No.
you would
no,
not be
I would just
thinking-
admit it. I mean, why? I would not do all of this just for my reputation. I just wouldn't.
No.
No, it's a lot of work. A lot of work. A lot
And,
of
and
gotta
honestly,
be.
I mean, and think about it. Your reputation is when somebody admits something they've done and they own it and they apologize for it and they take on whatever the consequences may be and they move on. That says a lot more about you than this.
Oh, yeah.
Yeah, it's that old quote, right? Don't worry about your reputation, worry about your character. I think that's John Wooden. John, is that who it is? I can't remember. I love that quote though, but
Yeah.
it's true. Like, worry about your character. Like, everybody makes mistakes. All of us do. I mean, some of us
Sure
make
do.
terrible, horrible mistakes. What you do after that mistake is what
Yes.
defines you.
Yes.
Mhm.
Well, she's been defined, that's for sure.
Oh, for sure. For
Mhm.
sure.
Okay, 2A. In arguing the absolute immunity doctrine does not apply, Ms. Reed expressly acknowledges that the doctrine forbids claims based on a witness's testimony or an alleged conspiracy to provide false testimony. She also concedes that even witnesses who testify falsely may not be held liable for their false statements to the grand jury and false testimony at the trial. As outlined in the opening motion, the AC amended complaint relies on exactly this type of protected conduct over a dozen times. Yet, despite now recognizing that the statements made during judicial proceedings are immune from liability, Ms. Reed continues to pursue claims that depend on exactly that. Each claim brought against the Commonwealth witnesses directly alleges that, one, they coordinated to tell the investigators that Mr. O'Keefe never entered 34 Fairview and that Ms. Reed made inculpatory statements. Keep that, bookmark that. And then two, some of them provided false testimony at Reed's criminal trials, and three, Ms. McCabe lied to a separate law enforcement agency in 2023. Having occurred during the investigation and prosecution of Ms. Reed, the allegations underlying each of Ms. Reed's causes of actions are at their core activities that the absolute immunity doctrine has protected for centuries. Accordingly, Ms. Reed's concession that the Commonwealth witnesses are immune from liability for their grand jury and trial testimony leaves her complaint as a hollow shell that fails to satisfy the requisite pleading standards. To counter this unavoidable reality, Ms. Reed attempts to salvage her claims by arguing that the Commonwealth witnesses' initial statements to first responders on the morning of January 29th somehow fall outside the doctrine's protection. Because, according to Ms. Reed, no criminal or judicial proceedings were then being contemplated or proposed.
What?
She's like making the
goodness.
opposite argument, right?
Yeah. What?
Yet again, the argument mischaracterizes both the amended complaint and the law. First, Ms. Reed's characterization of what occurred the morning of January 29th ignores her own pleading, which is the point.
Mhm, exactly.
According to the amended complaint, by the time the Commonwealth witnesses spoke with Sergeant Lank, officers had already arrived at the scene in response to a 911 call. A victim had been transported to the hospital and a police investigation was plainly underway, right? So she's boxing herself into this impossible position.
This is an insane argument.
It is
Holy crap.
again, like when you go back and you read it and you read what Waters wrote, I mean, it will make you insane because I was like, I do not understand what you're saying.
And
I
it's
do not
so
understand.
well laid out. Like because at first you don't catch it, right? And then you go through them laying it out and you're like, oh my God.
Yeah, I thought I was going crazy. I was like, well, I'm not smart enough for Waters because I don't understand anything that you're saying here, bud.
Indeed. The amended complaint itself states that the investigation begins. So this is a quote. So they're quoting from the complaint. When CPD officers arrived, quote, on scene shortly after 6 a.m. And critically, it alleges that Sergeant Lank, the very officer to whom the Commonwealth witnesses spoke, was the detective sergeant who opined on a telephone call to MSP Homicide that Officer O'Keefe, quote, looked like he had been in a fight. Thus, the amended complaint places the statement squarely in the context of a law enforcement investigation into a suspicious death in which homicide was already being contemplated.
Right.
Ms. Reed cannot now reframe her own allegations to argue that no investigation was contemplated or proposed at the time the Commonwealth statements were made. That is contrary to her own pleading.
And it's ridiculous because there is no way that a man of John's age who has died in the snow is going to be a natural death. Like that boggles my mind how she would say there's not an investigation going on. Of course there's going to be an investigation. It's not a natural death.
But also, doesn't it move the ball on the statute of limitations, which we'll get to in a little bit? Doesn't it kind of move the ball on the date a little bit?
A little bit.
Nevertheless, in support, Ms. Reed cites a single case, blah, blah, but that case actually undermines her argument. Here, the statements to Sergeant Lank were made in the context of an active police response to a 911 call reporting an unresponsive person, a situation which Sergeant Lank reported to be suspicious with multiple officers already on scene. This is not a situation where a private citizen made the accusation, which might otherwise never have been known. So they're saying that a 911 call is a petitioning activity.
Yeah.
They're not saying that they called 911 and said Karen Reed murdered John O'Keefe.
Right.
Are you sure, Lydia? There's not a call that says that. Are you sure?
And she's not even alleging that, right? She's not even saying that what started the investigation was someone saying she killed someone.
Right. Right.
I mean, even the medic testified that they heard Jen shushing Karen, right? When Karen was saying,
yes.
Oh, yeah. We're going to get to that.
Yes.
That's in here.
Oh, okay.
Yeah, because Jen thought she was being crazy.
Right. Yeah, it's wild. So
God bless the judge, by the way.
Yeah.
Oh my gosh. I mean, all judges really.
All
I
of
just,
them.
Yes, it's
you
true.
just think about how much they're filtering. They're like the filters of the legal system. It's just incredible what they have to read.
The
Mhm.
patience, the
Yeah.
amount of patience this would take.
Yeah. So there is a footnote on this page, regardless, even if this court were to adopt Miss Reed's novel theory. And I have to say, I love the word novel every single time I see it in a footnote. Stripped of the protected testimony and statements to investigating officers that followed, i.e., the grand jury testimony, trial testimony, later statements to law enforcement, remaining initial statements cannot independently support any of the causes of action. The amended complaint itself underscores this point. The overwhelming majority of Ms. Reed's allegations against the Commonwealth witnesses concern their statements to MSP investigators. Their testimony before the state grand jury, their testimony at trial, and their statements to a, quote, separate law enforcement agency. All of that conduct is concededly protected. The elements of each claim, as discussed in the opening motion, require far more than a few initial remarks to a responding officer at the scene of a death investigation.
Yep.
Ms. Reed's only other attempt to escape the absolute immunity doctrine is to characterize certain alleged conduct, such as moving Officer O'Keefe's body, destroying phones, and deleting evidence as, quote, non-testimonial actions to which absolute immunity does not attach. Even assuming the truth of these baseless allegations, they do not by themselves support any element underlying Ms. Reed's claims. For example, an allegation that one or more of the Commonwealth, and she keeps saying this,
It's just, crazy. It's crazy. Like
You don't get to do that. You have to be specific.
Yes.
Relocated Officer O'Keefe's body is not relevant to whether any particular Commonwealth witnesses commenced or continued criminal proceedings against Ms. Reed. The phone destruction allegations similarly do not state a claim. Mr. Albert and Mr. Higgins maintained their phones until well after Ms. Reed's arrest and indictment, and therefore these acts could not possibly have contributed to law enforcement decision to charge and prosecute Ms. Reed. So here they're just saying if you accept linear time as a construct, right, that things happen in a linear order, then you can't say that something that happened after the arrest caused the arrest. I mean, it seems simple on its face, but
and that's the whole crux of everything. Like all of these claims that she's making after the fact, they do not matter because they did not lead to Karen being arrested for the death
because
of
they
John.
occurred temporally later in time.
Right. Even like we've said before, Nicole Albert's testimony and Higgins or statement to the police and Higgins' statement to the police occurred after she was arrested. She cannot claim any of those led to her arrest.
Right. This is like
so even if it was true, it doesn't matter. It doesn't matter.
The phone destruction allegations similarly do not state a claim. Mr. Albert, did I already read this? Sorry, I did. And even if the body relocation or phone destruction allegations were intended to show that subsequent statements to police were motivated by a desire to cover up wrongdoing, that motivation does not strip the testimony and witness statements of their absolute protection. So even if they did everything she said that they did, they still have protection under petitioning activity. Immunity covers all statements by a witness, regardless of a motive. And then they have the cite.
And can we just say again, because I don't think it's said enough, especially with Brian Albert's phone, that went all the way to the Supreme Court.
Right.
And the Supreme Court said there is no legal basis for you to get his phone. So, yeah, I just, we need to keep repeating that because they didn't destroy anything and she was never entitled to it.
It is the most misunderstood fact, I feel like, that I hear. I mean, people believe that 100% until you correct them with the information.
Yeah. Yeah. They think it was just Canoni that said you can't have the phones. That's not what happened.
Right. Right. Yeah. She was just step one.
Yeah. And they wouldn't dare try to take Higgins or any of the other witnesses' phones to the Supreme Court. Brian was their best shot, right? So, because there was a connection to Jen and there were some communications. They never had a legal basis to get those phones.
In sum, once the protected conduct is stripped away, as it must be, the amended complaint is left with nothing more than vague, group-led allegations of non-communicative conduct that cannot independently satisfy the elements of any claim against any individual Commonwealth witness. Accordingly, the absolute immunity doctrine requires dismissal. And there's a footnote that says, as outlined in the opening motion, should this case proceed to discovery, the Commonwealth witnesses will establish that Ms. Reed's continued assertions that Mr. Albert and Mr. Higgins discarded or destroyed their phones are entirely false.
Because they are entirely false.
And what sucks for her too is that, the United States Attorney's Office gave Higgins and Albert's attorneys the permission to state in open court that they had, cooperated fully with them. They were not the target of any investigation, that's going to come in. I mean, how often does something like that happen?
Right.
That the United States Attorney's Office allows you to say that.
And there can't be a conspiracy, right? Michael Proctor can't be in a conspiracy without being in, without the witnesses being involved. So then that by way of saying that, you're basically saying that never happened, Karen.
Yep.
I haven't read all the titles, but this one's kind of funny. Ms. Reed does not dispute that she became aware of the pertinent facts underlying most of her causes of action in June of 2022. So here's where we go back to a discussion of linear time. Mm-hmm. As the opening motion demonstrates, by June 10, 2022, Ms. Reed obtained all the Commonwealth statements to police, which the complaint illustrates were foundational in the conspiracy to frame her. She had the extraction data from Ms. McCabe's phone, which she describes as providing a, quote, window into the conspiracy and misconduct. Oops. That's a swing and a miss. Mm-hmm. And by September 2022, she deployed this evidence in a Rule 17 motion to argue the exact same conspiratorial theory that she presented in the amended complaint. In opposition, Ms. Reed does not dispute any of this. She does not claim to have discovered the alleged conspiracy at some later date. She does not invoke the discovery rule. She does not allege fraudulent concealment. The reason for that is obvious. The public record, which the complaint incorporates by reference, forecloses any such argument. Under settled law, a plaintiff does not have to possess actual knowledge of every element of her claim. Accrual occurs as soon as a plaintiff possesses knowledge of the facts sufficient to put her on inquiry notice of a possible claim. Cite: Ms. Reed had far more than inquiry notice by June 2022. She had foundation for her entire case. The conspiracy, MCRA, and IIED claims are time barred, which has been stated over and over again in their filings.
And by this time, right, that she's aware of it and the dates that they put here, she's actively reaching out to the U.S. Attorney's Office.
Right.
Yep.
So she actually took an action based on the information that she had.
Right. Right. That's insane.
Oopsie.
It's insane.
Karen. Oh, Karen.
The thrust of Ms. Reed's statute of limitations argument is that all of her claims, including the Section 1983 conspiracy, MCRA, common law conspiracy, and IAED claims, are really malicious prosecution claims that did not accrue until her acquittal. See opposition at 20. But the First Circuit has already rejected this very theory. In Cite, the plaintiffs made the same argument Ms. Reed now makes, alleging a single conspiracy that encompassed their false arrest, the filing of baseless charges, and the ensuing malicious prosecution, to argue that the limitations period on the entire conspiracy did not begin until acquittal. The court squarely rejected this theory, refusing to treat all components of a conspiracy as a unit, which is a recurring problem, right? As the court explained, the fact of the conspiracy does not toll the statute of limitations with respect to earlier clear-cut violations of rights that have not been concealed from the plaintiff. This, quote, separate running rule has been applied consistently in this circuit. The complaint itself alleges the Commonwealth witnesses' false statements caused Ms. Reed's wrongful indictment, that's a problem, arrest, and prosecution. But the alleged injuries from these actions, including her arrest, indictment, and the emotional distress and civil rights violations she claims to have suffered as a result, were known to her by June of 2022. The fact that a prosecution followed does not defer accrual on claims whose injuries were already realized. That's a huge wrinkle in time. Ms. Reed's opposition relies on cite. However, McDonough did not establish the broad rule Ms. Reed needs. It addressed the narrow question of when a fabricated evidence claim against individuals actually prosecuting the plaintiff accrues, and held that such a claim, which is most naturally understood as a malicious prosecution claim, does not accrue until the criminal proceedings terminate. So it's just like a misread of that, not to be confused with misread. The court's reasoning was tied to the elements of malicious prosecution, which requires favorable termination as a prerequisite to suit. McDonough did not hold, however, that every claim tangentially connected to a prosecution accrues only upon acquittal. The interpretation would swallow the rule the circuit has long recognized. Each civil rights violation accrues when the plaintiff knows or should know of the injury, regardless of whether or not a prosecution is pending.
Yeah.
So
the only thing that could really save her here is a DeLorean. Go back in time and try to change something, I guess.
I heard those are coming back.
My friend growing up, her dad had one. And I remember her pulled to school several times, and it was like the coolest thing, just showing up.
Gosh.
So hilarious. Okay, so they have a footnote. So they have a citation. They say it's particularly instructive. There, this court confronted a plaintiff who had served nearly 27 years for murder he did not commit. This one just cracks me up. And he sought to invoke a heck-type tolling rule to preserve his state common law conspiracy claim. The court declined to extend the favorable termination accrual rule to the plaintiff's common law claims, holding that the plaintiff knew or should have known of his injury well before the limitations period, and that crafting a broad tolling exception would be an unprecedented overstep. If a plaintiff wrongfully imprisoned for 27 years cannot invoke a generalized tolling rule to save his state law conspiracy claim, Ms. Reed, who was free on bail throughout her prosecution, certainly cannot.
That's amazing.
It's 27 years. 27 years. The opposition insists that counts 3 through 7 of the complaint expressly allege that the House defendants participated in a conspiracy to maliciously prosecute Ms. Reed. How did they don't even have the ability to prosecute her. That's the thing that's so wild about what they're saying here. Not merely to have her wrongfully arrested, but labeling a claim is not the same as establishing a substance. Courts do not simply accept a plaintiff's characterization of her claims at face value. They examine the constitutional right at stake to determine the applicable accrual rule. This court should look at what the complaint actually alleges. The gravamen of Ms. Reed's claims against the Commonwealth witnesses is that they one, made false statements to police in late January and early February 2022, 2, agreed to tell a false story, and 3, allegedly destroyed or concealed evidence.
January and early February. Sorry.
What?
I'm sorry. I don't know if you guys heard that.
Oh, no worries.
I just thought she echoed. Oh, okay.
No, I was just making sure something was working on my phone. Sorry.
Oh.
These are allegations of conduct purportedly designed to cause Ms. Reed's arrest in February 2022. The opposition attempts to layer on allegations that the Commonwealth witnesses continue to coordinate their stories with police throughout the prosecution, but these allegations of continued coordination are precisely the kind of mere continuance of a conspiracy that the First Circuit has held does not affect the accrual of the limitation period with respect to a completed object of a conspiracy. So then the footnote for this is Miss Reed cites several cases for the proposition that claims premised on false evidence and infirm prosecutions do not accrue until the underlying. So she's saying this, here's my evidence for saying it doesn't matter until after the acquittal. The very case she cites, however, preclude the result she seeks. For example, in cite, the court's analysis was specific to malicious prosecution claims. The court separately assessed the timelines of the plaintiff's IAD and other tort claims, noting that those claims had different accrual dates. The Arias court allowed certain emotional distress claims to proceed alongside malicious prosecution claims only because those claims were intertwined with the prosecution itself, which they obviously weren't here, not because it adopted a blanket rule that all claims remotely connected to a prosecution accrued acquittal. Moreover, and most notably for purposes of the litigation, the Arias court dismissed the claims brought against the lay witnesses for the very reason outlined here and in the opening motion.
Why would they quote that?
I don't know. That is confusing.
Yeah, same reason they would attach testimony that does not say what they said.
Yeah.
You think it says. Like,
it's nuts. Ms. Reed's theory, taken to its logical conclusion, would mean any civil plaintiff who is also a criminal defendant could defer accrual of any claim, no matter how attenuated its connection to the prosecution, until after the criminal case concludes. And of course, I think we all know. I mean, we've seen examples of that. We know that is not the law, as they say. The separate running rule exists precisely to prevent plaintiffs from using the umbrella of a criminal prosecution to toll the limitations period on claims that are fully formed and ripe for adjudication. Ms. Reed had 3 years from June 2022 to bring these 3 claims. She waited until November 2025, and only after her acquittal gave her a platform to file suit. The tactical choice does not overwrite the statute of limitations. The claims are time barred. That was a really long way to say the claims are time barred.
yeah.
So that was the original. I mean, that assertion in the original document that we read was so strong and clear about the time bar. I can't even believe they have to address it.
Yeah.
Honestly.
Yeah, I remember. Yeah, you're right. There was no doubt about it.
No, it was the strongest argument, I felt like, in the document. Is the time barring alone would throw it out, and then you can just, the rest of it is like window dressing.
Great. Yeah, it was just gravy.
Ms. Reed now argues that the Commonwealth witnesses initiated the entire prosecution by casting Ms. Reed as a suspect even before the investigation started. The characterization fundamentally misstates both law and the complaint's allegations, her complaint's allegations. A citizen who provides information to law enforcement does not thereby commence or continue a prosecution. The defendant's share in continuing the prosecution must be active, as by insisting upon or urging further prosecution. The opposition relies on cite, but that case proves the Commonwealth witness's point, not Ms. Reed's. As she acknowledges in cite, the court rejected malicious prosecution claim against FBI agents accused of shoring up a false story precisely because there was no proof the defendants voluntarily reached out to law enforcement officials and caused them to commence a new line of inquiry. So, and we all know what happened that day, right? Nobody was calling and saying you have to investigate Karen Reed. None of these people. There's no evidence of that at all.
And the federal investigation came to a close. You think,
right?
You went silent again, Tuesday. There you go.
Oh, I'm back.
You're
back.
back.
You're back.
I don't know why it does that. So bizarre. But yeah, the federal investigation came to a close with zero indications of any conspiring. You know, they looked into this and nothing came of it.
Yep.
And they say the complaint here presents even a weaker case. There's simply no allegation that any Commonwealth witness, and this is actually what was interesting to me about this sentence is this is not even something we saw on social media, right? We've never seen a claim that any of these people said you have to investigate Karen Reed. Yeah. That's not even a edge case. Mm-hmm. So they did not press the police to apply for a complaint. Quote.
Right. I was going to say, where's the proof of this?
There's not even fictional proof of it.
Right.
Demanded or directed the police to arrest Miss Reed or otherwise asserted control over the prosecution. Fatally, the complaint is devoid of allegations that any Commonwealth witness ever implicated Miss Reed in Officer O'Keefe's death. They merely reported that Officer O'Keefe did not enter 34 Fairview. And what they observed about Miss Reed in the morning, Officer O'Keefe's body was found. No Commonwealth witness is alleged to have ever told the police or testified that Miss Reed killed Officer O'Keefe. And we know that from having watched both trials, right?
Mm-hmm. And her affidavit confirms this.
Mm-hmm. Yeah. And the 911 call and the testimony and all of it. Nor does the complaint allege that any Commonwealth witness ever told any police or prosecutor that Miss Reed should be arrested, indicted, or prosecuted. Miss Reed's attempt to distinguish site by arguing that the Commonwealth witnesses directed first responders and investigators to Miss Reed almost immediately. And I highlighted this because of what you were saying earlier, Tuesday, that Jen was like, please stop talking. You're talking crazy. What is going on? She actively prevented Karen Reed from saying, I hit him, right?
Right.
That's what was happening at the scene.
I mean, there's just so many, not that we want to go down that rabbit hole at the moment, but there are just so many things that if they were framing Karen, they would have actually done, and they had the opportunity to do that they didn't do. So
many things.
It's so weird.
And they actually did the opposite of what you would expect if they were trying to point the finger at her, right?
Yeah.
That day, there was just, so many options they had.
She blames everyone but herself. I mean, we've seen it in her text. She blames John's family for prosecution. Everyone but herself is to blame.
She blames John for that night.
Yes.
Yeah, most of all.
Yeah.
This is compulsory rhetoric unsupported by the complaint's own allegations, as evidenced by the opposition's lack of citation. The complaint admits that a separate independent investigation into the death of Officer O'Keefe was undertaken, which after review produced no additional arrests, indictments, or charges prior to its closure. That fact is fundamentally inconsistent with and undermines any inference that the Commonwealth witnesses exercised a peculiar degree of control over the Commonwealth's independent prosecutorial authority or its charging decisions. I'm sorry.
No, I was just going to say that, they all have this idea in their head that Jen McCabe controls everyone's thoughts. She coordinated everything going on. And
right.
Okay.
I just want to take a moment and say hello to my husband because he just texted. He's not home right now. He's like, I have your live on. That's adorable. So hi
Tuesday, husband.
Hello, Mr. Tuesday. Hello, Mr. Tuesday. Thank you for letting us borrow her so much. Miss Reed's 1983 conspiracy claim requires her to plead in some detail a relationship or cooperation between the Commonwealth witnesses and state actors. Cite The opposition makes clear that Ms. Reed's allegations do not satisfy the standard. The pre-existing relationship Ms. Reed describes is speculative, backdoor chain running through multiple non-parties who were not alleged to have participated in any conspiracy, which I'm totally borrowing this language. So that's a great sentence.
Yeah, this is great.
I won't read this sentence yet because I want to read the footnote, which is the fact that Ms. McCabe is alleged to have reached out to law enforcement 3 hours after leaving 34 Fairview on January 29th does not alter the court's analysis. Merely reporting to police what Ms. Reed said on the morning of January 29th, which under oath Ms. Reed conspicuously failed to refute.
I love it. I was about to say that.
So good. Does not constitute, quote, pressuring law enforcement to do anything. What law enforcement ultimately chose to do with the information provided by Ms. McCabe does not by proxy automatically implicate McCabe in the prosecution's commencement.
Nope.
And then there's another footnote that says this argument also relies entirely on the statement that the Commonwealth witnesses made to the police, which Ms. Reed has already conceded are entirely immune from liability under clear, controlling Supreme Court authority. I mean, the part about Jen McCabe, so let's say you go to the doctor and you tell the doctor something that is happening and the doctor thinks you made it up. It's not like, so if Jen McCabe tells the police that XYZ was happening, what the police decide to do with that, that's part of the investigation, right? So if I go to the doctor and I'm like, I swear I feel like I have a tiny elephant embedded behind my eyeball, what my doctor does with that information is likely going to be very different from what I perceive in my delusion that I have a tiny elephant embedded behind my eyeball, right?
Right.
So Jen McCabe could say anything she wanted to the police, and the police are going to do with it what the police are going to do with it.
But Jen McCabe has special powers, right?
She does.
Brainwash.
Mind control.
Mind control.
Mind control. She's mind controlled me many times.
She has me too. I wish she would like control my thermostat a little bit better. But whatever, Jen.
Get it together, Jen.
Yeah, come on, Jen. Rude. Okay, so the allegations that the Alberts and Proctors knew one another and that Mr. Albert and Mr. Higgins also worked in law enforcement cannot possibly impute state action, which occurs only in rare circumstances. Right? The complaint lacks any allegation that the Commonwealth witnesses ever spoke with law enforcement outside of their statements given in January and early February 2022. And I thought this was really important. So they're speaking to law enforcement, right, in these statements. And they're saying it's not like there was some giant underground, like, communication between these witnesses and the police outside of these statements. So that confers the, fact that they were petitioning activities, right? They were talking to the police as one does when you're a witness in a murder case, and there's no evidence that there was anything outside of that. The assertion that some sort of back channel communication was going on through defendant Proctor's sister, who then apparently communicated with Mr. Albert's sister-in-law, who then apparently communicated with the Commonwealth witnesses, is far too attenuated to impute state action on private parties, especially when the complaint fails to allege that those communications had anything to do with law enforcement's decision-making. So they're just saying this is very tenuous. It doesn't make any sense, and there's no evidence that there was actual communication with people who were working on the prosecution, right?
Yeah, and as a reminder, the feds had all those communications.
Right.
The only thing that was born out of those communications was Julie Albert offering a gift, which never was given. And I think, in my personal opinion, was cast into a light that was not her intention. That was not a bribe.
No,
Right.
it was, that absolutely was not her intention.
So we don't have to wonder about what these communications were, because the federal government already looked at them, and there was none of that there.
Right. Yeah. So it says her allegations are precisely the type of speculation fueled by the plaintiff's own suspicions that courts routinely reject in this context. Hashtag Sarah Boone. The court should do the same here. So then they get into the common law conspiracy. The opposition states that the Commonwealth witnesses entered a common plan to make it look like Mr. O'Keefe died due to exposure after being hit by Ms. Reed's car, and that they took multiple steps to carry out the plan, including moving Mr. O'Keefe's body to the area of the front lawn where Ms. Reed had dropped him off. The opposition then defends this body relocation theory as supported by the snowplow driver's testimony that he did not see a body at 2:30 a.m. and based on purported testimony from a medical examiner that Officer O'Keefe's injuries were inconsistent with being struck by a vehicle. However, Ms. Reed's own allegations undercut this conspiracy theory entirely. So then there's a footnote. Again, Ms. Reed's civil conspiracy claim is dependent upon her malicious prosecution claim because the underlying tort is insufficiently pled. The conspiracy count necessarily fails. That's an important fallback, and they're saying it doesn't matter what's being asserted here because it fails because the underlying tort is not pled properly.
I saw something the other day on Twitter, which, I think we've all thought about it, but it was just put so simply. It was, Lucky didn't see John, Jen, Matt, right. Everybody leaving the house. Nobody saw John. The only person that saw John was Karen Reed.
Mm-hmm. Under a mound of snow, mind you.
Where she expected to find him.
Yes.
Right. It kind of reminds me of the whole Murdaugh thing where they say 3 people went down to the kennels, only 2 came back.
Yeah.
Of all of these people, she's the only one who went straight to where John was at.
Yeah. It's so depressing.
Yeah.
Honestly.
Yeah.
Okay. The complaint concedes that Miss McCabe arrived home with her husband at approximately 2:12 a.m. and remained there, and that Mr. Higgins was seen in the parking lot of the Canton Police Department at 1:30 a.m. Her own timeline thus excludes multiple Commonwealth witnesses from the very conduct she alleges against them as a group. What are you going to do with that?
Yep.
How do you get past that? Just as a person with a functioning brain. Anyway.
Yeah. Where is everybody else in the house? Why isn't she going after everybody that was in that house?
Mm-hmm. Good question.
Yeah, it's nuts. Okay, so then there's a site, and then in parentheses, vague group-led allegations are insufficient to state a claim. So that is just a great note to people who like to read legal filings. You can't do these group-led allegations. This comes up over and over and over again in different cases. Moreover, as detailed supra, the opposition's own evidence confirms that the medical examiner never testified that Officer O'Keefe's injuries were inconsistent with a vehicle strike. To the contrary, she opined that they could have been consistent with a vehicle strike. The remaining allegations are similarly meritless, as described in the opening motion, even accepting the allegations as true. And this is a theme throughout. So even if you say it's true, then they'll still knock it down legally. Mm-hmm. The Commonwealth witnesses were not committing a wrongful act when they told police that Officer O'Keefe never entered 34 Fairview. Even if they were aware of additional facts pertaining to the death of Officer O'Keefe, a citizen ordinarily has no obligation to volunteer exculpatory information to law enforcement authorities. So again, I thought of the 911 example. So if I call 911, I see someone stabbing someone at a 7-Eleven, And then I say, but you know what? His mom said he was really super nice. Like, I am not obligated to do that. I'm obligated to just report what I see or know as part
Mhm.
of petitioning activity. I don't have to give anything else to law enforcement.
I
That
remember when they put this in the last filing, and yeah, it's
Oh, did they?
yeah. They
No.
talked about it. That yeah, I mean, they cited the same thing that they have no legal obligation to. So yeah, I mean, whatever, if they had anything saying that she didn't do it, they didn't have to provide it to
Right, like a witness is a defense attorney. So a
yeah.
witness is like, yeah, well, I saw him stab the guy, but also that makes
Yeah, they definitely put it in because it stood out to me.
interesting.
Mhm.
Do you think Karen wrote that motion?
Sure seems like it to me. I don't know.
No, I mean,
God, I hope so.
Right? Like, I can't believe a legal professional wrote that.
I know it's concerning. I mean,
Yeah.
I really, yeah, it's concerning because they're,
Yeah. Yeah. I wonder how much she's contributing because I mean, I don't think that they're lying when they say they're working for free at this point because how the
yeah,
hell could she afford all of this? You know?
yeah.
So
I
I
don't
do
know.
wonder how much that she's contributing because of that.
It's amazing how I don't know how she brokers these deals with these people and gets them to do exactly what I could see if she was, a multimillionaire
right.
and just telling her attorneys, you're going to do this, you're going to do this, you're going to do this. But then when people are not, according to her, she's not paying them. How are you doing that? How are you making those demands? It's wild. It's really wild, especially when you look at it, like it reflects poorly on these attorneys. Like it's not done well. It looks like it's done by Karen Reid.
It really does look like she wrote this,
Yeah.
or at least held the pen.
Or it was, yeah,
And who was
based on
Yeah.
what
And
she
there's
saw.
so many themes in it, right? So she's
Right.
angry at everyone. It's all their fault. They're doing it to her. The witnesses did this to her. The
Yeah.
accused did this to her.
Mhm.
It's got a lot of Karen weaved into it.
Yeah, it's a recycling program.
Recycling program.
Thus, Miss Reed's conspiracy theory fails as a matter of law. Cite, a conspiracy requires an agreement to commit a wrongful act. So then they move on to the MCRA. The opposition contends only that causing law enforcement to prosecute Miss Reed was intrinsically coercive under the MCRA. And what has now become thematic throughout this motion practice, the argument improperly conflates the actions of law enforcement with those of private citizens, which I think is one of the most important, repeated points in this document. The intrinsic coercion doctrine applies only where the defendant themselves effectuated an arrest or detention, such as directing an officer to arrest someone, which we all know did not happen here. So this is they make this point multiple times, and I think it's an important one. Then they have a cite. It does not extend to private citizens who provided witness statements that were later incorporated into an independent law enforcement investigation and grand jury indictment, especially when those private citizens never gave statements implicating Miss Reed or requesting that Miss Reed be arrested, which we know none of them did. Such an expansion of the doctrine would effectively eliminate the threats, intimidation, or coercion requirement for any witness whose statements contributed to a prosecution. Indeed, this court recently held that conducting a sham investigation of the actual perpetrator, coaching, coercing, or otherwise fabricating evidence against the plaintiff, or causing witnesses to give statements and or testimony that will result in misidentification, or by offering false statements and testimony, do not constitute threats, intimidation, or coercion under the MCRA. So on to intentional infliction of emotional distress. In support
Before
of
you move on,
oh,
I'm just laughing at this, requesting that Miss Reed be arrested. I mean, can you imagine?
I know.
Hey guys, it's Jen. So, like, could you guys just like arrest her?
Can you imagine
Jen here.
if we all had the power to do that? Wouldn't we be doing that all the time? We're like,
Of course, there's so many people on Twitter I would have arrested.
can you please, for the love of God, arrest the person that came up with the new Dawn soap, dish soap scent? I would be all over that. I would do it immediately.
I mean,
With
maybe
extreme
Karen
prejudice.
does think that exists. I mean, her dad called the police for a ride.
You know?
So, I mean, maybe
That
they
is
think
a good
that.
point.
You could
That's
do that.
fair.
I don't know.
Yeah, it's so imperious and weird, though. It's weird. I don't know. I don't like it. So here comes IAD. So she relies on site, arguing that it is a mirror image of her case, sort of like how she also thinks she's Deep Throat. Side note.
Yes.
That characterization is not just misleading, it's preposterous. Site involved FBI agents who assisted an informant in doctoring statements, framed scapegoats, and scrambled to cover up the frame job by obstructing the scapegoat's efforts to clear their name. The extraordinary level of sustained governmental corruption and official misconduct prevalent in site bears no resemblance to the circumstances alleged against the Commonwealth witnesses, which involve private citizens providing witness statements. Ms. Reed's attempt to analogize site is legally and factually baseless and should be rejected. Conclusion. This is short and sweet.
It is dumb.
It's so crazy. That last one is so crazy.
Yeah.
So for the foregoing reasons, the court should dismiss Ms. Reed's amended complaint against the Commonwealth witnesses with prejudice, award them their attorney's fees, and grant any other relief the court deems just and proper. Which, it's so insane. Like when you read all of the things, I mean, time barred aside, which was my biggest issue with the very first complaint, time barred aside, the rest of it is ridiculous.
Yep.
So what do you do with that as a judge?
Can you guys hear me?
Yeah.
Yes.
We can
Okay.
hear you.
My mic cut out earlier, and so I'm going to backtrack just a tad. When you were reading the part about Karen asserting that Jen McCabe would call and be like, "Excuse me, I need someone arrested." Like anyone who has law enforcement in their family.
Right.
Oh, you're gone.
Oh,
Come back Tuesday. Come back to us.
I want to know what you're doing.
Yeah, me too. I want to hear the rest of this.
What is it?
Tell us. You're
Keep
muted.
going, Tuesday. Nope. Still muted.
Sign language, smoke signals, anything.
Send it to us in Morse code.
She needs the Hector from Breaking Bad. She needs the little. Come on, Tuesday. Fix whatever is wrong. What is going on?
Tell
What
us.
It's
Is it
Jen. It's Jen
There you go.
McCabe.
Oh, there you are.
Jen
Tell
did
us.
it.
Tell us what you were going to say. That sounded really interesting.
Well, I was just making a point that anyone who has law enforcement in their family or friends, no, it's not a thing that you can't just call your
No,
your friend up, your family member. I mean, I
no.
have an uncle who worked the LAPD 100 years ago, and he would be laughing at me if I
Yeah.
ever called and was like, "Hi,
That doesn't work.
arrest this
That
person."
does not work.
No.
No.
Right. Hey guys, I gotta go. Somebody just texted me and needs me to arrest somebody. I'll be back. I mean, it's ridiculous.
It's crazy. I mean, the whole thing is crazy.
I lived next to our police chief for I don't know how many years. The thought that he would ever do anything that I asked him to do is so ridiculous. It's ridiculous.
Yeah.
So do we know what happens from here? Like, is there a hearing for this, or does the judge just look at both of them?
I don't
Now
know.
there's a hearing, right?
I don't know. I'm
I'm
pulling
less
up the docket right
familiar
now.
with federal. I don't know.
I think that was the next step. I think they got to reply to her reply
And then there's a
after
hearing.
the amended complaint. Like, so she filed the amended complaint, they replied. She got to reply again, and then they replied. And now, yes, I believe a hearing is set.
So
I think I have that. Right.
hearing or argument, like, did they get to argue at federal court, or is it?
Yeah, I think it's an argument. I think you're right.
Okay, I'm going to pull up the
Don't quote me.
deadlines and hearings. Let's see.
Yeah, don't quote me. I had it somewhere, but now I can't find it.
So yeah, the
How
only thing I can
dare
see is
you.
like the response deadlines. So I don't know
Yeah,
if she
I don't
makes a
know.
decision without like, I don't know, you guys. I don't know.
I don't know.
We'll
I
find
don't
out.
know.
Yeah, that's.
I have it somewhere. I'll find it.
Thank you. Maybe we can post that when we.
Yeah.
Yeah. And I just sent to you guys the report on Ian Whiffin's report on John's phone. I don't know
Oh,
if you
thank
want
you so much.
to. I don't know how to do it. If somebody knows how to post it on Twitter.
I can post it on our YouTube channel too.
Oh, that would be great if you could
Yeah.
post it. I'm sure people would like to see it. And like,
Yeah,
it
thank
is-
you.
I'm just warning you guys, it's really difficult. It's really
You think-
difficult
Yeah, I know.
Yeah. It
to
is.
go through that report. It's very sad.
Might have to save that for the weekend.
Yeah. It's training to see it.
Yeah.
I
Yeah,
just
it's,
go back to remember that Karen did that interview in the car with Ted Daniels. And
Yes.
she was talking about how she was reading everything on John's phone down to his heartbeat, which is
Yes.
that's
It's so
not possible.
creepy.
And the way she was speaking about it, and this was a man that, she was, very personally connected to.
Yeah.
She was talking about it like, well, it rained yesterday, and then, reading that report, it's just, it's a gut punch. It's a serious gut punch.
Yeah. It's sad.
But not if you're Karen Reed.
Yeah.
Can you guys hear me?
We can
Yes.
hear you.
Oh, okay. Just checking.
I want to shout out Tuesday, as a matter of fact, for all the work, amazing work she did on the jury episode, which
Yes.
is upcoming. It's outstanding. So stay tuned for that. And also, we miss Carrie tonight.
Yes, we do miss Carrie
Yeah.
for sure.
And yeah, I'm looking forward to the jury thing. I mean, I think everyone's played a role in helping find and locate things. Takes a village.
You're the GOAT, though. You did it. It was amazing.
Yeah, it's a kind of amazing with this particular jury. You normally don't have the quantity of interviews
Right.
that you have. Like, this was a very vocal,
It's unusual.
very unusual.
Yeah. And the more you start to poll, the more there is, the more
Yes.
you remember.
Yeah.
And it's not just the jury per se, but it's the comments about the jurors from people
Twitter and Facebook.
thing. I mean, there's just so many elements to it. And then noticing the things that the jurors say that were not even part of the trial.
Yeah, that was interesting.
That's really big in this. Yeah. Mm-hmm.
Yeah.
Yeah.
Dying for y'all to see that. So
Yeah.
Yes. So we will get that rescheduled
today. And
our problem is we go down these rabbit holes. So we're all focused on whatever it is. And then there's a side quest that demands our attention. Feeling, and then, but we have lots of content coming. So.
Yeah. And it's going to be a busy month.
It is.
I don't know what happened today with the protective order and the defamation case. I don't know what happened in that hearing. There wasn't anything filed afterwards, but then we have the hearing for the defamation case in the anti-SLAPP one. That is in July. And then, and I know Carrie really wants to go over it. Aiden's second motion to dismiss, which, that should be great.
Mega.
Yeah. So
Big
we got a lot. We got a lot this summer.
Yep.
So
thanks for your patience as we juggle all that.
Lydia, for reading that entire.
Yes. Thank you so much.
Thank you. Sorry, I'm losing my voice.
No, it was perfect. Yeah, it was perfect.
Well, we will see you guys next week.
Yeah.
Okay. No 3-hour one tonight, guys. We did
good. We should get a prize.
It must be Carrie's fault, guys. It's got to be Carrie's fault.
It's all Carrie. Y'all tag her. Or Carrie's fault.
All right. Good night.
Good night, guys.